All right, everyone, let's jump straight into a power-packed revision of a super important chapter, incorporation of a company. First, let's kick things off with a classic ICI problem. Look at this scenario. A private company is down to one member. They carry on for 7 months and then take a big loan. Can the bank come after that member's personal property? This is a classic trap where so many students lose marks, but don't worry. By the end of our session, you'll see this question and know exactly how to answer it. Okay, first up, promoters. Before a company even exists, someone has to have the idea, do the groundwork, and get everything ready. That person, or group of people, is the promoter. So let's define who the law actually considers a promoter. Now, the legal definition in Section 269 is actually pretty wide. It's not just the person who came up with the idea. The law says you're a promoter if you meet any one of these conditions. Your name is in the prospectus, you have control over the company's affairs, or the board of directors is used to acting on your advice. So, to break it down, you could be a promoter just by being named in the annual return, or by being a major shareholder who calls the shots. But, and this is absolutely crucial, this is where marks are lost. Look at that exam tip. A lawyer, a CA, an accountant, if they're just giving advice in their professional role, they are not promoters. ICAI loves to test this exception, so don't fall for it. Okay, quick check. True or false? Does a promoter have to be there from day one? The answer is a big, fat false. Think about it. Someone could come in later, help the company raise a bunch of money, and gain significant influence. They would absolutely be considered a promoter. It's about their role and influence, not just the timing.
All right, let's move on to the nuts and bolts. Section 3 of the Act. This is the bedrock, laying out the most basic, non-negotiable requirements for forming any company.
Stop and memorize this. Seriously, this is prime MCQ territory. For a public company, you need a minimum of 7 members. For a private company, at least 2. And for a one-person company, well, the clue's in the name, just 1. Remember these numbers: 7, 2, 1. Simple, but so important. Next, Section 3 says you have to define the member's liability. You've got 3 choices. Limited by shares, which is the most common. Here, you're only on the hook for any unpaid amount on your shares. Then there's limited by guarantee, where you promise to pay a certain amount if the company winds up. And finally, the scary one, an unlimited company, where there's no limit to your liability at all. Now, here's one of those little details ICII loves to throw in. If you're forming a company in a special zone, like an international financial services center, you don't get a choice. It has to be a company limited by shares. It's a small point, but it could easily be a 1-mark question. Okay, let's zoom in on a special kind of company, the OPC. This was a cool innovation in the 2013 Act, and it has some very specific rules you need to know. So, who can actually form an OPC? The rules are strict. First, you have to be a natural person, a real human being, not another company. You must be an Indian citizen, and you can't be a minor. Now, you can be a resident or a non-resident, that's fine. Also, there are things an OPC can't do. It can't be a nonprofit company, and it can't be in the business of non-banking financial investments. Now, remember we mentioned resident. For OPC purposes, the magic number is 120 days. Please do not get this confused with the 182 days you see elsewhere. For an OPC, if you've been in India for 120 days or more in the last financial year, you qualify as a resident. Okay, this next part is a hot spot for exam questions, so listen up. Every OPC needs a nominee, right? To take over if the member dies. Simple. But here's the twist, the one-person rule. You can be a member of only one OPC and a nominee in only one other OPC. So what if the member of the OPC where you're a nominee passes away? Suddenly you're a member of 2 OPCs. The law recognizes this and gives you a 180-day window to fix the situation and get back in line with the rule. So what happens if the nominee changes? Well, the clock starts ticking immediately. The moment a change is needed, the sole member has just 15 days to pick a new nominee. And that's not all. After that, the company itself has 30 days to file the paperwork, Form INC-4, with the registrar. 2 separate deadlines to remember: 15 days for the member, 30 days for the company. So with all these rules, why bother with an OPC? Well, it's all about the perks. The law gives OPCs some major breaks on compliance. You don't need to prepare a cash flow statement. The annual return can be signed by just one director. You don't have to hold an AGM, and you only need one board meeting every 6 months. That's a huge reduction in paperwork. All right, everyone, it's time. Let's solve the puzzle I gave you at the start. That private company with one member left. Does he have to pay the company's loan from his own pocket? The answer lies in the dangerous territory of Section 3A.
This slide is the whole game. When the number of members drops below the legal minimum, the law doesn't pounce right away. You get a safety window, a 6-month grace period. During these 6 months, business is as usual. But if the company keeps going after 6 months with too few members, then the remaining members become personally liable. And here is the key, the absolute key. They are only liable for debts taken on after the 6 months are over. But wait, it's not automatic. For this personal liability to kick in, it's like a 3-part test. And all 3 conditions must be true. 1, the number of members is too low. 2, the business continues for more than 6 months like this. And 3, the member knew about it. In our example, the member continued for 7 months, so conditions 1 and 2 are met. And he was the only one left, so of course he was aware.
So let's hammer this home one last time. True or false? The answer is a huge, flashing, neon false. This is the biggest trap in this section. The liability is not for all debts, and it does not start from day one. It is only for debts contracted after the 6-month grace period has expired. Burn this into your memory. The loan taken in the 7th month? Yes, that member is personally liable for that one.
Okay, last section. We know the rules, we know the traps. Now let's just quickly run through the actual process. How do you bring a company to life according to Section 7? Think of it like a 6-step journey. You pick a name, draft your key documents, the MOA and AOA, and then you file everything online using the big SPICE Plus form. You submit all your other paperwork, pay your fees, and if everything checks out, the registrar issues the Certificate of Incorporation. That's it. That's the company's birth certificate.
Now let's look at the paperwork. The MOA and AOA are obvious, but pay very close attention to these next two, a declaration and an affidavit. They sound similar, but they are totally different. The declaration is from a professional, like a CA, saying, yep, all the rules have been followed. The affidavit is a sworn statement from the first directors and subscribers themselves, saying I'm not a convict, I haven't committed fraud, and everything I've said is true. You have to know who gives which document.
All right, let's dive into one of the most critical documents in all of company law, the Memorandum of Association. Picture this. You're in the exam hall, totally focused on a big question about company incorporation. You feel like you've got it all covered. But wait, there's a tiny little word in the company's name, a word that's actually a classic ICAI trap. If you miss it, you could lose some really easy marks. Well, we're here to make sure that trap doesn't get you. So, check this out. Here's a perfect example of what I'm talking about. A classic exam-style problem. You're asked to advise a client who wants to start a company called Barak Development Scheme Limited. Now, what's the first thing most students do? They just check if the name is available, right? And that right there is the mistake. There's a much bigger issue at play, and it all comes back to the company's foundational document. First up, the MOA, the absolute foundation of any company. So let's get into why it's called the company's constitution. So what exactly is the Memorandum of Association? Think of it literally as the company's constitution. It's the charter that lays out the ground rules. It's a public document, which means anyone from shareholders and creditors to you and me can look it up and see exactly what the company is all about, what it's allowed to do, and more importantly, what it's not allowed to do. It basically defines the company's entire relationship with the outside world. The entire MOA is built around a few key sections, or clauses. We've got the name clause, the situation clause, the objects clause, liability, capital, and the subscription clause. Oh, and don't forget, there's also a nomination clause, but that one's just for one-person companies, or OPCs. We'll touch on all of these. Okay, let's get into the first big one, and you really need to pay attention here, the name clause. This is probably one of the most tested areas, and trust me, it's where a lot of students lose marks unnecessarily. The first rule is super simple, but you gotta know it cold. If it's a public company, the name has to end with the word limited. If it's a private company, it has to end with private limited. Easy enough, right? But there are always exceptions. Section 8 companies, the ones for charitable purposes, don't need to use these words. Same goes for certain IFSC companies which operate in special financial zones and have their own set of rules. So, how do you actually get a name approved? Well, it depends. If you're setting up a brand new company, you'll apply for the name as part of the main incorporation form, which is called Spice Plus. It's all integrated. But if you're an existing company that just wants to change its name, you'll use a different web service called RUN, which stands for Reserve Unique Name. Two different paths for two different situations. Okay, so what names will get flat out rejected? Section 4, subsection 2 gives us three main rules. First, your name can't be identical to, or as the law says, resemble too nearly an existing company's name. And we're going to dig into what resemble means in just a second, because it's tricky. Second, the name can't be something that's an offense under any law. And third, it can't be considered undesirable by the central government. And this power is usually exercised by the Registrar of Companies, the ROC. And here we are, back at our exam question. Remember that trap I mentioned? This is it. You can't just use a name that implies you're connected to the government unless you get prior approval from the central government. This means words like board, commission, national, union, even president, or Rashtrapati are off limits without permission. And here's the kicker, the exact point of the trap. Using the phrase development scheme together with a word like government, state, India, or Bharat is a huge red flag. So, Bharat Development Scheme Limited? No way. Not without that government approval. That's the whole point. Okay, exam tip. Listen up, because this is where ICAI loves to twist things. That phrase, resemble too nearly, what does it actually mean? It's not just about a name being spelled the same. It's much broader, and it's perfect for case studies. Let's break it down so you don't get caught. So what counts as resembling another name? It's a whole list of things. For example, plurals don't make a difference. Green technology is the same as Green's technology. Capital letters and spaces? Ignored. So ABC Ltd is considered identical to A.B.C Ltd. Different verb tenses, like ascend versus ascended, same thing. Even tiny spelling variations like disc with a C versus disc with a K are a no-go. Phonetic spelling counts too, so BK Limited is the same as BK Limited. And this one's really clever, even a full translation. So National Electricity Corporation is considered the same as Rashtriya Vidyut Nigam. You have to be super careful with these rules. Okay, so let's say the ROC approves your name. Great. How long do you have to use it? Well, if it's for a brand new company, that name is reserved for you for 20 days. But if you're an existing company changing your name, you get a bit more time. The reservation period is 60 days. Now, what happens if you furnish wrong information to get your name approved? The consequences are pretty serious. If your company hasn't been formed yet, the name reservation is simply canceled, and the person who applied could be hit with a penalty of up to 1 lakh rupees. But if the company is already incorporated based on that bad info, the ROC has some major powers. They can tell you to change the name within 3 months, or they can strike the name off the register, or, in the most extreme cases, even start the process of winding up the company. So yeah, being truthful in your application is a very big deal. All right, let's move on to the next part of the MOA, the situation clause. This is all about the company's address or its domicile. Sounds simple, but it has some really important legal consequences. So why does this matter so much? Well, the situation clause establishes the company's legal home, its domicile. This is crucial because it determines which ROC and which NCLT, the National Company Law Tribunal, has jurisdiction over the company. It's also the official address where all legal notices and communications are sent. Now, here's a key detail. The MOA itself only needs to mention the state where the registered office is located. You have to provide the full, exact address to the ROC within 30 days of incorporation.
We've now arrived at the objects clause, and a concept that is an absolute favorite of examiners. I'm talking about the doctrine of ultravirus. I want you to think of this as the company's Lakshman Rekha, an invisible line drawn around its powers that it can never cross.
Ultravirus. It's a Latin phrase that literally means beyond the powers. So any act, any transaction that the company does which isn't authorized by its objects clause is considered ultravirus. And here is the most important thing to remember. Such an act isn't just invalid or cancelable. It is completely null and void from the very start. It's as if it never happened. The case that cemented this whole doctrine is a classic, Ashbury Railway Company versus Riche. So in this company's MOA, its objects clause said its business was to make and sell railway plants, and also to work as general contractors. Pretty clear, right? But then the company went and signed a contract to finance the building of a whole new railway line in Belgium. So the big question for the court was this. Does the term general contractor include something like financing a huge project? Or is it strictly about building and selling things, their main business? What do you think? Well, the House of Lords came back with a landmark decision. They declared that the financing contract was ultra vires, and therefore it was completely null and void. But here's the part you absolutely must remember for your exams. They said that even if every single shareholder in the company had agreed to this deal, it still couldn't be ratified. You cannot make a void act valid. An act that's ultra vires the MOA is simply beyond repair. So let's quickly recap the effects of an ultra vires act. 1, it's totally void. 2, any member of the company can go to court and get an injunction to stop the company from going ahead with it. And 3, since the agreement is void, neither the company nor the other party can sue on it to enforce it. It's a dead end. Okay, let's wrap up by looking at the last few clauses, which are all about money and the promises made by the founding members. This covers liability, capital, and subscription. The liability clause is actually pretty simple. If a company is limited by shares, a shareholder is only liable for the amount that's still unpaid on their shares. That's it. If they've paid in full, their liability is 0. Now, for a company limited by guarantee, a member's liability is limited to a specific amount they promise to pay, but only if the company is being wound up and needs the money. Let's look at a quick example to make this crystal clear. We have Modern Furniture Ltd. The share value is 10 rupees, and the company has called up 8. So look at Mr. Singh. He's paid the 8 rupees that were called up. His remaining liability is just that unpaid 2 rupees per share, for a total of 400 rupees. Now, Ms. Sarla has paid the full 10 rupees, even what wasn't called up yet. So her liability? Nil, 0. But then we have Mr. Sanju, who has only paid 6 rupees. He's still on the hook for the remaining 4 rupees per share, meaning his liability is 1,000 rupees. See how that works? It's all about what's unpaid. The last 2 main clauses are the capital clause and the subscription clause. The capital clause just states the total authorized share capital, the maximum amount the company can raise, and how it's divided up into shares. Then, the subscription clause is where the very first subscribers sign their names and state how many shares they'll take, which has to be at least 1. And as we said before, if it's an OPC, a one-person company, it also needs a nomination clause to name who takes over if the sole member passes away or can't continue. We're tackling one of the most important sections in company law, Section 8. We're going to break down every rule, every penalty, and every privilege you need to absolutely ace this in your exams. But first, let's start with a classic ICAI exam trap. So picture this. A company gets its shiny new Certificate of Incorporation. Everything seems fine. But plot twist, the objects written in its memorandum are totally illegal. So my question to you is, does that certificate somehow make the company legit? What do you think? And the answer is a big fat no. This is a super important point, so listen closely. The Certificate of Incorporation is not the final word on the legality of its objects. If the objects are legal to begin with, no piece of paper can make them legal. The only way out for that company is to be wound up. This is a fundamental point where students often lose marks. Okay, now let's make this more practical, like a case study you'd see in your exam. Imagine 3 friends, maybe you and your buddies, want to open an academy to promote sports education. You want the protection of a company, that awesome separate legal entity status, but you're not in it to make a profit for yourselves. So what's the best legal structure for them? Well, this is the perfect setup for a Section 8 company. All right, let's dive into the heart of it. What does it actually take to form a Section 8 company? What are the absolute must-haves, the foundational requirements? Let's break it down. You have to remember these 3 golden rules. They are completely non-negotiable. First, your main purpose has to be charitable. We're talking things like promoting art, science, sports, education, social welfare, that kind of good stuff. Second, you have to plan on putting all your profits and any other income right back into promoting those charitable objects. And third, you are strictly forbidden from paying dividends to your members. Get these 3 things down and you've understood the very soul of a Section 8 company. Now, this slide has some really interesting points you need to know. First, even though they have limited liability, these companies don't have to use the words limited or private limited in their name. Kind of cool, right? Second, despite that, they still get all the benefits and have all the responsibilities of a regular limited company. And third, star this one. Highlight it, do whatever you need to do. ICAI loves to test this. A partnership firm can become a member of a Section 8 company. Yes, it can. So, who gets left out? This right here is prime MCQ territory. A one-person company or an OPC is a no-go. It cannot be formed as or converted into a Section 8 company. The rules flat out prohibit it.
Similarly, a small company, as defined in the Act, is also excluded. You need to remember these two exceptions.
Okay, you need to pay very close attention here because this is where students lose easy marks. The powers of the central government are given to two different authorities, the Registrar of Companies, or ROC, and the Regional Director, or RD. Knowing who does what is critical. The ROC handles things like granting the initial license and approving changes to the articles. But the RD handles the really big stuff, altering the memorandum for conversion and, most importantly, revoking a license. Don't mix them up.
Okay, so we've covered the basics. Now let's get into the nitty-gritty of the procedures. How do you actually get one registered? And what happens when you need to change your core documents, like the MOA or AOA?
For registration, your main application is the eForm SPICE Plus, which is Form Inc. 32, and it goes to the ROC. Along with that, you need to attach a few key things. Your MOA and AOA, of course, a declaration from a professional, like a CA or a CS, saying everything's in order, a financial forecast for the next 3 years, and finally, a declaration from every single person who is applying.
I'm going to repeat this because it is just that important. You cannot afford to mess this up. If a Section 8 company wants to change its key documents, who gives the approval? For the Articles of Association, you need permission from the ROC. But for the Memorandum of Association, you have to go to the Regional Director. AOA is ROC, MOA is RD. Got it? Now for the heavy-duty topics. What happens when a Section 8 company wants to stop being charitable and become a regular, for-profit company? And what if they break the rules and the government yanks their license? These are complex processes, so let's walk through them step by step. So, if a company wants to convert, first it has to pass a special resolution. Then, it files an application with the regional director using Form INC 18. After that, it has to send out notices to a bunch of authorities and also publish a public notice in the newspaper using Form INC 19. And here's a crucial point. All their financial statements and annual returns must be filed and up to date. Only after the RD gives the green light can they finally change their MOA and AOA. And who exactly gets these notices? Well, the list is long. We're talking the Chief Commissioner of Income Tax, the local income tax officer, the Charity Commissioner, the Chief Secretary of the state, pretty much any government department that might have an interest. Now, here is the exam tip. These authorities have exactly 60 days to raise any objections with the regional director. Remember that 60-day window. So, what can get a company into enough trouble for the regional director to revoke its license? There are 4 main reasons. 1, they just break the basic rules of Section 8. 2, they run the company fraudulently. 3, they start doing things that go against their own charitable objects. Or 4, their actions are harmful to the public interest. But before the license is revoked, the company has to be given a fair chance to explain itself. So, the license is gone. What happens next? The consequences are really severe. First, the special status is gone. The ROC will slap limited or private limited back onto the company's name. Then, the central government can either order the company to be shut down completely, as in wound up, or it can force the company to merge with another Section 8 company that has similar goals. Any money or property left over after winding up gets passed on to another Section 8 company or into the Insolvency and Bankruptcy Fund. When it comes to Section 8, you've got a classic stick and carrot situation. The punishments for breaking the rules, the stick, are really harsh. But if you follow the rules, you get some pretty nice benefits, the carrot. Let's start with the stick. And wow, is it a big one. If the company messes up and doesn't comply with the requirements, the fine is huge. It starts at a minimum of 10 lakh rupees and can go all the way up to 1 crore rupees. These are serious numbers.
And it's not just the company that's in trouble. Every single officer who's at fault is personally on the hook. Their fine starts at 25,000 rupees and can go up to a staggering 25 lakh rupees. And if there was any fraud involved, then the heavy-duty provisions of Section 447 get triggered. And that is a place nobody wants to be.
Okay, enough with the doom and gloom. Let's talk about the carrot. Section 8 companies get some pretty sweet perks. They can call a general meeting with just 14 clear days' notice, instead of the usual 21. The rules about having a minimum number of directors or independent directors, they don't apply. Plus, they don't have to bother with setting up certain committees, like the Nomination and Remuneration Committee. Okay, to wrap things up, let's go back to the very foundation of company law, the power of incorporation. This is Section 9, and it applies to all companies, including our Section 8 friends. This is what gives a company its legal superpowers. From the exact moment that Certificate of Incorporation is issued, a brand new legal person is born. The company becomes a body corporate. This means it has perpetual succession, so it can technically live forever, long after its members are gone. It can buy, own, and sell property, it can sign contracts, and maybe most importantly, it can sue people and be sued, all in its own name. This is that core concept of a separate legal entity.